SJC-12170, Commonwealth v. Stephen Mora.
Good morning, Mr. Shea.
Good morning. May it please the court, I'm Richard Shea for Stephen Mora. The first issue which I'd like to address this morning concerns the search warrant, and hopefully I will also have time to address the issue of the indictment for the sentence enhancement under the Armed Career Criminal Act.
Actually, I understand where you're coming from, but do you think you could start with the second? Could I do that to you?
If you request, Your Honor, I will.
Thank you.
She's leaving soon, so you're not done.
All right. The position which I take in a nutshell is that the sentence enhancement is, in effect, a separate crime. It's entitled to a jury trial. It's of significant concern to this defendant because of all the charges in the indictments. This one carries with it an increase of minimum maximum sentence of 7 years. All that is, the statute requires that he be charged with a prior violent offense. All the Commonwealth presented to the grand jury in this case in support of that indictment is the word robbery as the crime for which he had previously been convicted.
So I appreciate the point that robbery can be things that aren't a violent crime, wouldn't qualify under the ACA, but is your point really a practical one, that it's particularly unfair to have an indictment based on that, given the sword hanging over one's head with an ACA indictment against you?
Well, there's nothing, the law anticipates that if it's a violent enough robbery, yes, they're entitled to charge him and convict him with that. The question is whether under the McCarthy precedent, the indictment states probable cause to arrest for the crime. And my position is that there is no inference to be drawn from the word robbery that it's a violent crime of the nature.
Unlike the assault and battery one that you don't challenge.
Not challenging that one.
But on, I know that you cite to the Ninth Circuit case, the United States versus Parnell case, but the response to your argument is that unlike the federal statute, there's a separate jury trial.
That's correct.
And it's one indictment. And the point of the indictment is to notify the defendant that they're being charged through this indictment as an armed career criminal, and therefore stating robbery is enough and extrinsic for probable cause for McCarthy, and if necessary, extrinsic evidence can come in at a jury trial, which is completely different than how it works in the federal armed career criminal.
I'm not familiar with what exactly what the federal procedure is. I know in Massachusetts, the case law is clear that there has to be extrinsic evidence in order to persuade a jury beyond a reasonable doubt that the robbery is of the degree of violence contemplated by the statute.
Right.
I'm sorry, I understood your argument essentially to be that of Judge Krupps, in his opinion.
Yes.
And that, I think, is focused pretty much almost entirely on the opinion of this court in Eberhardt, citing Cologne, which says that the phrase physical force under the Armed Career Criminal law means, quote, violent or substantial force capable of causing pain or injury, and
Yes.
that robbery could be simply pulling a purse away from somebody and only requires force sufficient to obtain the property and may not necessarily rise to the level of violent or substantial force capable of causing pain or injury. Isn't that the heart of your argument?
Yes, it is. And the argument is that I would emphasize that a point that I made in my brief of appellant and in the reply brief, that when you're saying simply robbery, simply the word robbery in the indictment, it is ambiguous, and it proves nothing. And if you look at the Murray case, this court's decision in Commonwealth versus Murray, which I cite in the reply brief, which cites back to Commonwealth versus Berry about 20 or 30 years before, and all the cases in between, there is a principle of evidence that if two conflicting ideas can be drawn from a single piece of evidence, and they cancel each other out essentially because they're contradictory and they're equally possible, then it proves nothing. And the word that's used in the Berry case is it requires a leap of conjecture to go from the piece of evidence to the inference that an element of the crime has been proved. And I think that is exactly what is present here in the case of merely stating the word robbery in the indictment. This principle was recognized in a number of the federal cases and a Vermont case, which I cited in my original brief, that which was dealing with the standard of probable cause for arrest, which is what we're dealing with within the sufficiency of an indictment under the McCarthy precedent.
Okay, let's turn back to the safe. You have half your time left.
Right.
I guess I think what you would agree is that they saw a small safe, forget the name of it, but it is a safe, sorry?
Knox.
Fort Knox. And it is a safe which is apparently used to store a firearm. That, I gather you concede, is a hard fact.
Well, that's how it's advertised in a brochure that's attached to the affidavit of the police officer.
Okay, would that be sufficient in itself to support a search warrant?
No, because you need probable cause to believe that the firearm was not licensed.
Well, if it's locked in a safe and you hear a heavy metallic something banging around in there and it's locked in a safe, is that not a reasonable inference?
That it's unlicensed? No.
How about locked in the safe, hearing a metallic sound, and being in the car with somebody who at least had just purchased drugs and maybe was assisting the passenger, Mr. Echevarria, I think, with selling drugs? If you add that ingredient.
He hadn't. There was no proof that he had purchased drugs. My client's Mora, the driver. There was no evidence that he had purchased drugs. The only connection that was seen between him and Olivencia was Olivencia was standing in front of the store.
Well, I don't mean purchasing drugs at the moment. He's driving a car and there's needles in there.
Well,
so I didn't mean at that moment.
It's a fair inference at some point you could infer that he at some point had been using heroin.
I'm just asking if that just adds to that maybe he wasn't licensed.
No, because he could have been licensed to carry the needles, too.
Now, am I correct, actually, that a safe would be an appropriate way to store a firearm in a car because it would be secure?
It would be a secure, proper way to carry it. And I also have to go to the point that what we're investigating here, what the police were investigating here was not Mora. The crime that was being investigated, in which the case law, O'Day states it most explicitly in cases that I've quoted in my original brief, there's a particular crime that has to be under investigation in the search warrant affidavit, and the crime that was under investigation was Olivencia's distribution of heroin. It was not Mora's possession of a firearm. The affidavit attempts to build from the fact that Olivencia was engaging in hand-to-hand transfers which looked like drug transfers out in front of a store. His only connection to the car, Mora, and the safe was that Mora stepped out of the car, went up to him, looked around furtively when the last individual came up to do a hand-to-hand exchange with Olivencia. Then the two of them plus Olivencia's girlfriend get in the car. We don't know where anybody was sitting. The car, there was no furtive gestures that observed. The car was stopped a few minutes later by police. And Olivencia essentially had no connection to the safe, nor did he have any opportunity to get into the safe. It was at night on the floor of the rear passenger compartment behind the driver's seat. So it's a major stretch to go from Olivencia to that safe. Whatever Mora's connection with the safe was, Mora was not part of the drug distribution which the police were investigating and for which they were looking for a search warrant. They were looking for contraband that was related to drug distribution. And the guy that was doing the drug distribution was Olivencia.
Well, you don't think that you could infer that Mora himself was involved in that, given that at least as far as I could tell, the officer was in the parking lot for a while, and Olivencia was engaging in hand-to-hand sales. And then this guy comes along, and not only Olivencia, but his girlfriend get into the car and start driving, and when it gets stopped, there's a bunch of needles around. I mean, I don't know that it's not a reasonable inference that Mora himself is involved.
The needles, he could have been at some point. He could be a heroin user. And Olivencia might know quite a few heroin users. And a heroin user might give him a ride somewhere, but that doesn't mean that the heroin user is involved in the distribution of the drugs in front of that store at that given time.
Well, the Commonwealth is going to argue that on a joint venture theory, aider and abetter theory, that there's probable cause, especially when you hear Mora say that the other person's name is Josh. So the question is whether or not that allows for probable cause for the safe. But even if the warrant is seeking evidence of drugs, if the four corners of the affidavit constitute probable cause for the gun, then the warrant's good.
If they're...
It's Commonwealth versus El Monte. If there's probable cause for the gun, the fact that they think they're looking for drugs, their subjective view doesn't matter. It's what's the four corners of the affidavit.
But the only evidence that the gun... There's evidence to believe that there's a gun in the safe, but there's no probable cause to believe that the gun is unlicensed.
How about,
And the case law is clear that the Kuchar from this court makes it clear that the police cannot search for a gun unless they have probable cause to believe that it is unlicensed.
I'm thinking you're giving away too much, counsel, when you say that the police, that they didn't have probable cause to believe that he was unlicensed. I mean, I'm trying to get to probable cause to believe that there's a gun in there. I mean, they didn't believe that until they went to investigate the safe. And what else is there about this encounter that would suggest that that there's a gun there? I'm having trouble with that.
The evidence that there would be a gun there would be, number one, that this safe was advertised and designed to store a firearm, and secondly, that they shook the safe and it had a heavy metal object that was consistent with a gun. So that would be the inference that there was a gun in there. I'm not conceding that there was probable cause to believe that it was a gun. I'm saying that there was no probable cause to believe that the gun was unlicensed. I think that's the crucial distinction in this case.
So the flaw in the affidavit is the police officer should have run an inquiry to see if he was licensed.
Yes.
All right, thank you.
Thank you.
Ms. Lazar-Moore, good morning.
Good morning. Ellen Lazar-Moore for the Commonwealth. Beginning, I suppose, as the defendant did with the second claim, the Commonwealth would ask this court to affirm Judge Wren's order denying the defendant's motion to dismiss the armed career criminal charge because the evidence presented to the grand jury was sufficient to sustain that allegation. Judge Wren correctly concluded that at the grand jury stage, the fact that the defendant had been convicted of robbery was sufficient to demonstrate probable cause to believe that he had been convicted of a violent crime.
Why? I mean, given that robbery can sort of run a gamut of violence and force or not.
I think that sort of the common understanding by the grand jury of what robbery would entail, even if you look at the elements of the crime, that it's the taking from a person with force and violence or assault and putting in fear, that common understanding of those elements would be that that would qualify as a violent crime.
Isn't that what the dissenting judge or the concurrent judge in the Ninth Circuit said? He said, I thought this was nuts when I first read it. How could it be? But if you look at it,
Well, I think there are two issues. The first is what needs to be presented to the grand jury just to get the indictment. The second is robbery categorically a violent crime? And I think those are two separate issues. What Judge Wren decided is that at the grand jury stage, it's enough to present the grand jury with evidence that the defendant has been convicted of robbery, and that is sufficient for probable cause purposes. He actually agreed. I'm sorry. He agreed with the Parnell Ninth Circuit decision that it is not categorically a violent crime. And so it was his position that at trial, the Commonwealth would have to provide more evidence to show that the form of robbery committed by the defendant was a violent crime within the meaning of the Armed Career Criminal Act. So that really is what is before this court, is what needs to be presented to the grand jury. And it's the Commonwealth's position that Judge Wren correctly found that telling the grand jury that the defendant has been convicted of robbery is sufficient, at least for probable cause purposes.
But I mean, I guess, unlike other times before a grand jury, I mean, this is a crime that's already been adjudicated, right? It's a prior crime.
Yes.
So how hard would it be to figure out, to put in something to show that this actually was a robbery that involved force and violence? I mean, it's not terribly hard. You've got all the stuff that you need, don't you?
Well, Your Honor, I don't think the question is how hard would it be. I think is that the role of the grand jury at that stage of the proceedings, is that necessary? There are many different crimes that are charged with an enhancement where I believe that the grand jury is not given what a petty jury will later be given in a bifurcated trial to prove the enhancement beyond a reasonable doubt.
but those are usually convictions, aren't they? Those are convictions of they were subsequently convicted of a drug offense with most enhancements. And here, just like an assault and battery, in common sense would be assault and battery is a violent crime, but we know that that's not necessarily so. Same with robbery, perhaps.
Yes, but again, Your Honor, in Cologne, although the court said that not every form of assault and battery is categorically a violent offense for armed career criminal purposes, the court at no point said that the indictment was bad because the grand jury had not been given the evidence to make this determination before even issuing an indictment. And so that's really what Judge Wren decided, that this is just not necessary for probable cause purposes, and that if at trial a judge finds that robbery is not categorically a violent offense, then in the bifurcated portion of the trial where the armed career criminal portion of the indictment is tried, that the Commonwealth will then be required to present more evidence to allow the jury to find beyond a reasonable doubt that this was a qualifying form of robbery.
Are you
what-
conceding, I'm sorry,
Oh, go ahead.
I was just asking if, are you conceding that robbery is not categorically a violent offense?
No.
Okay.
Well, how can you not, in good faith? It says, or by assault and putting in fear. That is sufficient for robbery, is it not?
Yes, Your Honor, and I...
And you agree that it is sufficient to prove robbery, that to use simply the degree of force necessary to obtain the victim's property against his or her will, even if it's simply the tugging of a purse away from a woman.
Yes, Your Honor,
And
but...
do you agree that the definition of physical force that has been established by this court means, quote, violent or substantial force capable of causing pain or injury?
Yes.
And do you agree that the kind of assault and putting in fear that may or may not involve violent or substantial force capable of causing pain or injury?
So the definition
Yes or
of-
no? I mean, you say it's categorically within, but I don't see how you can in good conscience say that.
Yes, that's what I'm trying to explain.
Okay, please.
The definition of a violent crime within the Armed Career Criminal Act is the use, attempted use, or threatened use of physical force. It does not have to be the actual physical use of threatened force, of physical force. So in the example that you give, assault and putting in fear, in the Commonwealth, it's the Commonwealth's position that that is the threatened use of physical force. This court has defined assault and putting in fear for purposes of robbery or constructive use of force to require objectively menacing conduct on the part of the defendant intended to put the victim in fear, which actually does put the victim in fear of the use of force. So it's the Commonwealth's position that that is the threatened use of physical force, which would qualify as a violent crime under the Armed Career
I
Criminal
guess
Act.
the big issue on that is the pickpocket purse snatch.
Yes.
Where there's just, it doesn't have that gravamen of harm, right?
Right, so there are two, I think pickpocketing or picking pockets, whatever the right term would be, is different from purse snatching. They've been treated differently. That picking somebody's pocket does not necessarily qualify as robbery because the amount of force used doesn't rise to the level required for the force and violence required for robbery. And it's the Commonwealth's position that the level of force and violence required for robbery, even though it may not appear to be the violent force that the defendant says is necessary, is still enough because it has to be violent or substantial force capable of causing pain and injury. There doesn't have to be actual causing of pain and injury. And I use as an example in my brief a case called Commonwealth versus Fortes, which was a so-called purse snatching, where the victim either fell or the defendant pushed her down. He pulled her purse, she held on, she was dragged, had substantial knee injuries, and then had later surgery, and from complications of the surgery, she died.
So doesn't this then come down to when you analyze the word capable? If you're saying that violent or substantial force capable of causing injury or pain, a robbery is always capable of causing injury or pain, and you cite to a case that talks about in an involuntary manslaughter situation that may indeed occur. But are we looking at robbery in general as capable, or are we looking at, was this robbery the way it was committed, this robbery that's going to be the sentencing enhancement capable of causing injury or pain?
I think that it's always capable. I think that that's
If it
what
is,
makes
what's
it
the
categorically.
Okay, just assume it is for the purpose of my
Okay,
question, okay?
yes.
Just assume it is. how do we look at the word capable? Do we look at that robbery is always capable of it, or do we look at the circumstances of this robbery that's going to be the sentencing enhancement presented to the grand jury?
I think that if you say we're looking at the circumstances of this particular robbery, then we're saying that robbery is not categorically a violent crime, and that is the modified categorical approach. I believe that if we're looking at the form of robbery that is actual force and violence, as opposed to assault and putting in fear, which, as I said, I think is always the threatened use of physical force. But if it's actual force and violence, that it's the Commonwealth's position that that is force always capable of causing pain and injury. And this court has recognized that one of the reasons that robbery is an aggravated form of larceny is because of the potential for violence, because there's a substantial likelihood that a victim will resist when someone takes property from the victim's person, and so there's always a heightened danger of resistance leading to violence, and that's what differentiates robbery from other types of theft crimes like picking a pocket or larceny.
So it's your view it's capable in theory, not whether it was capable in this particular instance of the sentencing enhancement presented to the grand jury?
Yes, and not just capable in theory because anything in life is possible, but more capable because the nature of the crime, the physical taking of property from a person, this court has recognized repeatedly is very likely to provoke resistance from the victim, to provoke further violence by the defendant, and lead to pain and injury inflicted upon the victim.
Well, then how's the defendant supposed to know, even if it's not an element of the crime, through the charging mechanism, that extrinsic evidence is going to need to be presented to prove the case?
Well, I'm not sure that I understand your question.
Well, you're saying robbery, capable in general. So that's enough so that nothing needs to be presented to the grand jury other than what the underlying charge is.
Yes.
But that doesn't inform the defendant of actually what has to be proven at trial, which would require some extrinsic evidence if the robbery didn't actually constitute force.
Well, Your Honor, that would be the case with any type of crime that is categorically a violent crime. All that would then be put in both before the grand jury and then, I suppose, to a greater extent at the trial would be this defendant was convicted of robbery, here's a board of probation record, here's a plea transcript, here's whatever would normally be put in at the trial of any crime that's categorically a violent crime. If this court were to hold that robbery is categorically a violent crime, then it would be treated the same as any of those other crimes that are categorically a violent crime. It's only if the court were to say that it's not, and then at trial, the Commonwealth would be required to prove beyond a reasonable doubt using other evidence of what exactly was the nature of the type of robbery committed by this defendant, that evidence would be required.
If we can turn to the safe, what was the evidence that a firearm, if it were inside, was not licensed?
I think that inference could be drawn because of the presence or suspected presence of the firearm in connection with suspected criminal activity, which was the drug dealing. This, I believe, I'm trying to remember if it was this court or the appeals court, in two cases
Mr. Olivencia, I gather, was not seen bringing in the safe to the car.
No, he was not.
So we can infer that the safe was there before Olivencia and his girlfriend went inside.
Yes, probably, although the officer lost sight of the car for a couple of minutes, but there's no evidence that the officer saw Mr. Olivencia bringing the safe into the car.
And the car wasn't registered to either party?
No, the car was registered to someone else, and we never knew the connection of that person to the defendant or to Mr. Olivencia, but...
Wasn't it his mother? Do I have,
Michelle Bateman, I don't know that we know what the
is that his
connection.
mother?
I don't recall if there was later a determination made that that was
But
his
not
mother.
at the time that they knew that it was his mother.
Right. At that time, I know that the registration was in the name Michelle Bateman. I recall that the officer was unable to contact her and never spoke to her.
But was able to speak to the father, and that was suppressed ultimately.
Yes, the statements that the defendant made regarding the safes being his father, and he hasn't spoken to his father in a year, and then the conversation with the father that came after that, both of those were suppressed. So those were not considered by Judge Lemire in ruling on the motion to suppress.
So what is the evidence that there was probable cause to believe it was not properly licensed?
The fact that, so this court in Commonwealth versus Brookins and the appeals court in Commonwealth versus Edwards recognize that although the presence of a gun alone does not create probable cause to believe that the possession of the gun is illegal, the presence of a gun combined with other criminal activity may create probable cause to believe that the gun is unlicensed.
And the criminal activity being,
Being
The-
the drug activity that the officer observed, which I don't think should be limited to Mr. Olivencia. The evidence was that the officer was watching Mr. Olivencia make several hand-to-hand transactions. Then the defendant arrives, gets out of the car, stands with Mr. Olivencia looking around nervously while he makes another transaction.
Because
Then
he's
both-
selling drugs. That's why he's nervous. He's talking to his friend and he's making a transaction and he doesn't want any part of that.
Well, that's the inference that's one inference that could be drawn, but the fact that there's other innocent explanations for the behavior doesn't mean the magistrate would have to draw that inference. That the inference could be drawn that the defendant knew what was happening, went there for that reason, stood. If I went to see my friend and I realized he or she was doing a drug deal, I probably wouldn't stay there looking around until it was done, and then have him get in my car with his girlfriend and drive away with them. And then, of course, after the car...
I'm sorry, so what is the, I'm trying to think, what is the incriminating inference? That he was doing what?
That the defendant was either involved in the selling or was buying. He
But you say
waits
he was
while...
buying, but there were no heroin or, the search warrant says, quote, "No heroin or illegal narcotics were recovered from the vehicle or persons that occupied the vehicle." So they knew that there was nothing on Olivencia or on Mora.
Which would suggest he
Which
was involved
helps
in
to...
selling.
Which suggested that it was in the safe.
Isn't
That was part of...
Isn't the problem that most of our case law on the Couture-Alvarado line looks at whether or not someone handles a firearm or loads it at night or does things that are inconsistent with that of a lawful gun owner? And as has been raised in this case, a firearm in a firearm safe is permissible and actually required.
Perhaps if there's a license to have it outside of the home, then having it in a safe in the car would be, then it would be locked up. But I think in the Brookins and Edwards cases, although in those circumstances the evidence was that the gun was used or fired, so that was the criminal activity, the court didn't limit the statement to being only suspected gun crimes. It said the possession of the gun in conjunction with criminal activity suggested that the possession was illegal. And getting back to Chief Justice Gant's question, I had started to say that there's evidence of the drug dealing, there's evidence of the defendant arriving, waiting for the drug deal to be completed, looking around nervously. Olivencia and his girlfriend get in the car. When the police stop them and search them, they find needles and other drug paraphernalia both on the defendant and in the car, but no drugs, which Judge Lemire, I think, correctly found supported the inference that the drugs might be found in the safe. The warrant was granted not only to search for guns, but also to search for drugs and other drug-related materials.
What was I gonna?
It was a combination safe.
Actually, I think it was a key, and they didn't find the key. If the court has no further questions, I'll rest on my brief.
All right, thank you.
Thank you.